and not those of Vic Canellis Media Group, its parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Making Money with Laura Sanders, a name you can trust. With over 20 years of real estate experience and selling over 150 homes a year, Laura Sanders is the #1 RE/MAX agent in the state of Florida for 2021. Join us each week as we discuss how to make money through buying and flipping homes, to renting versus selling, and everything in between. To join the conversation, call in live. 888-994-4995, Studio A.
Hi, everyone. Welcome to Making Money with Laura Sanders, and I am your host, Laura Sanders. Every week, we talk about something that will help you make a little money, save a little money, or maybe just help you navigate this crazy world that we live in. Today, I want to talk about something that I find very frustrating, and I think it's corruption within the property management companies throughout Florida. I don't know if this goes on in other states, but I'm here to talk about this today with attorney Nick Fiorello with JK Closings. We're going to talk about this corruption and what you need to be looking for when going to sell your property, especially your condo. There is a new condo disclosure that came out in January that it's important to know the answers to the questions. But most owners aren't going to know the answers to these questions. So how do you find them out? Well, you would need to ask your condo management company. Sometimes you're self-managed, but most times you're not. And what is owed to these associations in order to get this information? Welcome, Nick.
Hi, how you doing?
I'm good. How are you?
I am doing great. Thank you for having me.
Thank you for being with us. So I found that lately there's some new requirements on the disclosure as of January 1, and it's a new section called the Milestone Inspection and Structural Integrity Reserve Study. Okay? And it says, has anything appeared in the association's agenda or minutes regarding milestone inspections and structural integrity reserve study for your complex? So this is what I always tell my sellers is, I need to see your minutes, your meeting minutes. And the reason why I ask for this is because in those minutes, it will discuss anything that could be a potential assessment moving forward. Do you recommend that that's a good idea?
Definitely. This all stems from the Surfside collapse a couple years back. Florida law has moved forward in a way to combat these either crooked, associations or management companies, or trying to shelter residents from a negligent board or a negligent management company. So, asking for this information that the condos are required to now have is really important, because at the end of the day, Florida law requires a seller of residential real property to affirmatively disclose to a buyer all known facts, material affecting the value of the property, which are not readily observable and are not known to the buyer. So inherently, these things going on in the back end of an association are never going to be known by a buyer.
Correct. So this is really something to be protective for the agent and for the seller, because ignorance is not an excuse. Just like when you're doing your taxes, it's not okay to not report all your income. So even though you say, well, my accountant said I didn't need to do it, well, that's not okay. So if they say, oh, my agent didn't tell me, I think that every agent should be getting this, and I think every seller should be making sure that they get this. Now, the agent can't get this information. This is information the seller needs to get directly from the HOA. The next thing is, has the association budgeted for the cost of hiring an engineer to complete? the milestone inspections and structural integrity reserve study. Now, most sellers, unless they're very, very involved, would not know the answers to that question. So again, I had reached out to an association recently, asked these questions, and they told me that this was an estoppel and that we needed to pay for it. These are not estoppel questions. This is on a paper that needs to be filled out by the seller, but I believe that the seller has the right to this information. Would you not agree, Nick?
The seller definitely has the right. I mean, and when they're selling their property, a buyer is entitled to receive copies of, governing docs and the financial documents for the association. So when, a seller is thinking about selling, the agent, who's representing them is going to help them formulate a plan, which is to get with the association, compile all of those documents so then they can disclose what is necessary to be disclosed to the buyer, because the buyer will have a way out of the contract until they get all of these documents.
Right. So that's one of the questions that most people don't know is the frequently asked questions. Now, without that, they can get out up until the day of closing if they have not provided that document. And most sellers do not know that. I've had a lot of condos recently, when I ask for the frequently asked questions, they tell me that we don't have that. And I send them a blank one. I go, we'll fill this out. And they go, oh, you have to pay for that.
That shouldn't be the case. That's something that they are required to have. That's something that they are required to have filled out and to be able to be distributed. And if they don't, they have the blank form that you were talking about. They have it available online, and that's when we provide it to them to be filled out. They shouldn't charge for that because that's something that needs to be provided to a seller when they're selling their property.
Right. So that's another thing that I just feel like every time you ask an association to do something, like, I get it, they charge for a background check. Totally, noted, right? They charge, but you ask them anything and they want to get paid for every single thing when they're already getting paid a management fee. That's their job, and they don't want to do the job.
No, never. It's a tough place to be when you're selling a condo already, and these companies that are in place and even the boards make it a little bit more difficult. And I understand there's a lot on their plates right now due to the change in legislative structure that's been happening in the state, but this is a result of negligent management and negligent running of these associations for years and years and years.
But the being short on reserves and that kind of stuff, that's one thing, but not willing to provide information. And when I said to them, this is a new law, you need to provide it. Well, what law is that? And they directed me over to legal till I threw you back in there. And now all of a sudden they're willing to give the information. I don't think that's fair, that's the way as agents we are treated. And I feel that a lot of people need to understand the corruption that is going on within these management companies. And I'm not afraid to say it. Like, they're
Definitely.
corrupt.
Definitely, and that's why we've had significant. Yep. Go ahead.
No, I mean, just playing games with you to get people approved. Oh, we didn't get one document when you ask them, do you have everything? And 10 days later, they come back and they say, oh, we're missing this one document. We asked you 10 days ago. And then if you call, they don't answer, they don't return calls, and then they say, well, now it's 30 business days from the day that we accepted it. And, the sellers are upset with you because they're like, well, why is this taking so long? Well, we asked if they had everything, but they wouldn't answer us.
I've seen a couple good ones where there have been checklists, and it has a little checkbox next to everything you need to provide, and that's been super helpful. I've seen from my end, but most of the time you don't have that, and that's not a requirement. but a lot of the other back end requirements that have been done are all leading to the financial and issues that have been stemming from financial and lack of reserves and stuff like that. But in terms of application, yeah, you're totally right. I mean, they don't answer. When they do answer, it's a one-word response. They don't answer you fully. Then that leads to another delay, and it's not fair to buyers and sellers.
It's a little crazy. And then it gives a bad taste to the buyers. But, let's go to commercial break. When we come back, let's talk about there's still more stuff on this milestone inspections and structural integrity reserve information that's being asked on the condo disclosure. And again, I want our audience to know that you should not have to pay for this information, and you are eligible to get this information directly from your management company. Don't let them push you around. Don't let them tell you it costs money, because it doesn't. So stay tuned. We're going to see our awesome sponsors, and we'll be right back.
At JK Closing Attorneys, we do all of the same things that a title company does, but with the benefits of being a law office. We can help with residential real estate, short sales, commercial real estate, refinances, 1031 exchanges, and FRIPTA withholding.
Contact JK Closing Attorneys today at 954-332-3111. Again, that is 954-332-3111.
Whether you're buying, selling, refinancing, or building your dream home, you have a lot riding on your loan specialist. Max Fish, a top 1% mortgage loan officer in the nation, will give you a same-day qualifying quote. Max Fish is committed to providing his customers with mortgage services that exceed their expectations. Ensuring that you make the right choice for you and your family is his ultimate goal. Contact Max Fish today at 954-729-6933 or max.fisch@nwmcorp.net.
You have been watching Making Money with Laura. For more information, contact Laura Sanders at 954-650-0827 or visit her website at laurasell.com. And now back to the show.
Welcome back to Making Money with Laura Sanders, and I am your host, Laura Sanders. So we're here talking about requirements with associations and what is required of you. I'm here with attorney Nick Fiorello, or Nicholas Fiorello, and we're talking about I feel it's corruption. I'm using the word corruption. I know that sounds harsh, but I'm frustrated. I'm frustrated because I think I'm exhausted from every time I list a property with a condo association that I'm pulling teeth to get information. You know, the owners are trying to get the information. I'm trying to get the information. They're pushing back. I mean, what is our recourse? Is there any recourse other than, why should we have to get somebody like you involved where technically that's costing $400 an hour? I don't think that's fair.
No, Florida enacted all of these legislative changes, and they're all aimed for enhancing safety, financial transparency, and the governance of condo associations. So, going back to the transparency, that's financial transparency, that's transparency as how they act, that's transparency on, what their reserves are, where the building is financially, structurally, all of those things that must be disclosed to owners in that building. And it's all because of negligently run boards and buildings that have been the case for years and years.
I know that you've had me that's reached out to you asking for help. How often is this happening in your office where agents are saying they're not giving me the information I need, they're pushing back? Is it just me? Be honest, because maybe I'm the only one that's asking for this.
But let's just say it's more often than not. We have a majority of the condos that we deal with where there's one issue or another. Most of them are getting with the times in accordance with the change of the laws, but there's still a pain in the you know what to deal with on other ends, like you were saying with the approval or getting some of this information from them that's required to be disclosed to the seller, which the seller is then required to disclose to the buyer. It happens way more often than not, but at the end of the day, a lot of these legislative changes that have been made are going to, we're in a transition right now into full compliance. And a lot of these buildings are either almost at compliance, or struggling to get there and working on getting to be in compliance. And then I think, hopefully, with all of these changes, when we get there, it's going to be a lot easier for a seller of a condo in order to sell. I'm not sure if we're 100% there yet.
Right. Well, I've told people that, maybe watch the next year. This will tell you where condos need to be, that they'll be actually in their most recent state and stay a little bit more stable. So the next thing that was on this section that was added recently, has the association hired an engineer to complete the milestone inspections and structural integrity reserve study yet? So this is another thing. And these studies are super expensive. And these studies are going to, if they have not even happened yet, beware, it will increase your maintenance, because whatever's founded, if they don't have reserves for it now, they're going to be adding it in the future. And all this has to be completed by, I think it's January 2026.
A lot of this had to be done by the end of the year, this past year.
I thought so too, by January of 2025, but I'm still seeing things are still kind of going on. So maybe people just aren't compliant.
And some of this doesn't apply. Yeah,
to two-story buildings.
Mainly some are not compliant, but yeah, exactly. So 2-story buildings don't apply. Single-story buildings don't apply. These are, 3 stories or higher for some of them, for the structural inspection and for the milestone inspection. So
maybe under 30 years of age.
The reserve study as well. Exactly. So it's when a building reaches 30 years of age, that's when they need to have this milestone inspection, and then every 10 years after. So we're not going to be waiting for years and years after this. Now there's a requirement every 10 years that they need to be doing these inspections to make sure the building's up to code, up to par, and structurally safe. And then in terms of their reserves are at a level that is going to be necessary to cover any of their, needed changes. But in the meantime, while we transition, we can expect special assessments and other different changes in the assessment structures on what's going to be assessed to each, condo owner.
Yeah. So again, these questions are on the new condo seller's disclosure. So I believe, because I've already had it, most sellers don't know the answers to these questions. And by leaving them blank or I do not know, I believe buyers are going to push back. They're going to want to know the answers. So you're going to have to push back with these associations to get the correct answers. So the last...
It's also on the contract as well. So actually on the condominium rider of the contract, it's on there as well. So it's actual contractual provision that's going to need to be responded to by a seller when going under contract for a condo unit.
Interesting. More work on to my day. Has the association, this is the last one, has the association passed or discussed raising fees or doing a special assessment to pay for costs associated with complying with the milestone inspection or structural integrity reserve? So that's just asking about more assessments. So realistically, here we're talking about buyer beware, seller beware, to make sure that you're disclosing the appropriate information to a buyer. Otherwise, I believe and you correct me if I'm wrong, you're opening yourself up to a ton of liability. That's why the corruption needs to stop. They need to stop asking us for money for things that should be provided to the seller. I just can't even say it enough. I just don't even know what to do. Like, these people, like, I don't even know what goes on in their brains.
It's difficult. It's a difficult place to be in, and then with the disclosure, like you said, I mean, even if they need to disclose something for a special assessment, like you were just talking about, the board or the management company needs to disclose at least 14 days prior to the condo owner. So, I mean, a seller or an owner is going to need to receive that notice before they even have consider a emergency special assessment to come up to code. So, it is, for a seller, it could be a waste of time because a buyer can back out up until closing if this stuff is not disclosed or not provided. And, if they do close, then it could be something where the buyer goes after the seller for not disclosing something, but then it'll be a whole conglomeration of litigation that might come to the result that the association never provided anything to the seller, so the seller didn't know anything to disclose. So it's a whole mess, and hopefully these new legislative acts help, bring everything back together.
Let me ask you a quick question. So I had a client that sold a property, and I guess 6 months, 7 months after she sold it, there was an assessment that came out. The man sent her a letter in the mail saying that you owe me this money for this assessment that you did not disclose. Now, she never owned the property. She inherited it from her mother. What do you think about something like that? What is the liability?
It's still on the seller to disclose anything that the seller should know about the property. So the seller, even in that case, they need to do their diligence and talk to the association and see if they can get a copy of the minutes, anything that might disclose a potential special assessment. And if that was active at the time that
Wouldn't it
person
come up on
sold,
the estoppel?
that buyer, not always, because the estoppel might show what's currently assessed, not something that might be pending. So there might be something that was discussed or on the agenda to discuss that would be in the minutes of the last meeting that might not show up on the estoppel because it's either not finalized or it's not ready to go yet.
Okay, but why couldn't a buyer do their due diligence, call the association themselves? When they're in their interview, why wouldn't they ask that question?
Because I'm not saying they shouldn't ask that. If you're a buyer, you should definitely do all your diligence. But it's the seller's responsibility as owner of the property to have that information and to disclose that information to a buyer, all stemming to what I had
Even if
talked
they
about
inherited it.
at first, even if they inherited it.
Okay. And then just out of curiosity, like, where does it
Because
put
at the end of the day,
where does it put
Go
us
ahead.
as the realtors?
I mean, the realtors, if they're asking and doing their diligence and asking the seller what information you have and asking the association what information they have, if nobody's providing it to you, how are you supposed to know?
Yeah, the way the contract used to be written, right? I feel that it was, hey, if you don't know, if you don't know anything, you don't need to say anything, right? Because there's nowhere asking for it. But now I'm very clear that if you know something, let's write it down, because if you write it down, you're not obligated to pay it. You've disclosed it. Unless the
Yeah,
contract
definitely. If you disclose something,
for something upcoming, right? That hasn't
yes.
been.
So, and then that's all part of the negotiation as well. So if it's disclosed up front, then the buyer and seller can talk about it in terms of who's going to be responsible, and that could be part of the seller accepting new offers. You know, they'll take the one that the buyer is willing to take that payment on.
So basically, the moral of the story here is that if you're thinking about selling your property, and it doesn't matter what kind of property, but definitely, if you have a condo and you're selling it, you should definitely call Nick Fiorello from JK Closings for representation. It's not required in the state of Florida, but I highly recommend it. The cost is similar to what you're going to pay anyway to the buyer's title company. So I would definitely recommend, if you're thinking about, selling or buying, definitely give Nick a call. What's the best way to reach you, Nick?
Definitely, you can call at 954-779-5000, or you can shoot me an email at nick@jkclosings.com.
And if you're thinking about buying or selling a home and you want the best realtor, well, I'm right here, Laura Sanders, RE/MAX Direct. Only ranking number 11 in the United States for all RE/MAX agents, so that's not too bad considering there's over 130,000 of us. And that actually makes me the number 1 woman realtor in the United States for RE/MAX. So again, not too bad. But if you're thinking about buying or selling, give me a call. Seriously, 954-650-0827, where I put you first. And don't make a move without me. Till next week, see you then.
Thank you for tuning in for Making Money with Laura Sanders, a name you can trust. To join the conversation, call us at the studio, 888-994-4995 Studio A, or contact Laura directly at 954-650-0827. Laura Sanders, a name